it's basically about in 1969, Branzburg wrote 2 articles where he went and observed people like doing drugs. And then when he was called to testify, he didn't want to reveal their names. He was appealing to the First Amendment, the right of freedom of press. But so he refused to testify on the 2 occasions that he went to, and he appealed to the Kentucky court, but it denied him. So then he went to the Supreme Court to protect the confidentiality of his witnesses. The Supreme Court agreed to review his case, and in 1972, the ruling was 5-4 against his case. The dissenting argument said the decision served to suppress any the press, like in the future cases, and the concurrent said talked about the rights of the press to have it, but it didn't really work out.
Okay, so to clarify, so this is about reporters who, it was like kind of in 3 different places, but this guy wrote for the Louisville Courier-Journal in Kentucky, and he wrote 3 articles about witnessing people making and selling drugs. And then he was actually subpoenaed to testify in front of a grand jury about what he saw, but he refused, saying that because he was a reporter, he had the right to free press without having to like testify before a jury to give information to try to prosecute people. And so he was held in contempt of court. So he filed a suit, went up to the Supreme Court. The Supreme Court ruled that even if you're a reporter and you feel that you have free press, like if it's with incriminating actions, like you still would have to testify based on what you saw in the situation. Questions?
Does freedom of press just mean you get to publish what you want, like that, like you can be questioned what you say, correct?
Right. I mean, it's a little more than that as well. Yeah, like you can publish what you want, but you can also say it. It can be written, you know, like it comes in different forms. Mm-hmm. But he basically was saying, because I'm a reporter, I should be able to write about anything I see, even if it's criminal, and not really be held responsible for like helping law enforcement. And the Supreme Court said, no, you do need to help law enforcement. Yeah. Zach?
What exactly is a subpoena? Is that just like a warrant?
A subpoena is a piece of paper that you get from actually a random person. And it says that you need to appear in court to testify on this day.
So it's not like a choice or anything?
No, it's not a choice. If you refuse a subpoena, you'll be arrested for contempt of court. Yeah.
So do you like print something that's false, like because people print false articles a lot, and it has evidence on it, and somebody takes it seriously and reports it, and then the police like want to get sued and then have to file evidence. Can you like recant your statement and the charges will be dropped, or
if you recant? Right, and reporters are called to grand juries, and grand juries are a group of people who decide if there's enough evidence to move forward. So it's not to an actual criminal trial, it's just to a jury trial. And if like somebody said, oh, well, turns out I wasn't telling the truth, then they would just drop all the charges before the trial began.
Okay.
Yeah.
Did the reporter get in trouble for lying?
Yeah, so we're actually going to start watching one of my favorite EMPs next week. It's called The Life of David Gale. And a reporter refused to give up the names of her sources who had done incriminating evidence, so she actually had to go to jail because she was held in contempt of court.
Is that because she lied?
She just refused to name the sources.
what's an EMP?
Educational multimedia presentation. Okay. All right. Thank you, Andrea.